My sister said this question.
All right. I'm going to ask. Good afternoon, everyone. Good to see you all here. This is the electoral board hearing for January. Oh, I thought I turned it on, excuse me. This is the electoral board hearing for January the 17th of 2023. And the order of business now is to call the meeting to order, which I have done. So, Madam Clerk, if you do a roll call, please.
Yes. Mayor Smith?
Here.
Madam Clerk Gray? Here. Trustee Hall?
Here.
Okay, we have
Okay, very good. And board, we need the adoption of the electoral board rules of procedure.
Mr. Mayor, I'll make that motion.
Okay,
I'll second.
very good. We have a motion and a second. A roll call, please.
Mayor Smith?
Yes.
Madam Clerk Gray? Yes. Trustee Hall?
Yes.
Motion passes.
All right, thank you. Next is citizens' comments, and I'll read it as I always do. Citizens wishing to address the electoral board with respect to any questions or statements are asked to sign up in advance for the deputy village clerk prior to the hearing. Comments will be limited to 3 minutes for each speaker. Do we have any speakers?
Yes, we have 3.
Okay, very good. You may call your first speaker.
Gary Wilson?
Good day, Mr. Mayor, rest of the board. A lot of times I'll sit back and kind of listen and watch as a prior board member some of the things that are going on. And several years ago, or I guess 3 or 4 years ago, when this petition came up to join the district, I'll be honest, I was not in favor of it because I don't feel that it's a true representation of Rantoul. And I think that this going into districts is not only not made Rantoul better, but it's divided. I think that this has divided the people into who said, they said. I don't agree with it. And on that petition that we signed 4 years ago, 3.5, 4 years ago, it asked for your name and your address. And that was basically it. Nowhere on there did it ask for your color of skin or your ethnic group or anything of that nature. And I just, to be honest, I'm tired of everything in Rantoul being about race. That's not what we are. That's not who we are. That's not where we came from. And I think that just further divides this country and further divides this village. Now, I would ask that when we go to the board or go to the elections in April, let this be placed and let this be a democracy, just like the United States was founded on. Let the people of Rantoul decide whether we should have districting or whether we should not. And then that's the way a democracy was made and the way it was created. We're not a dictatorship, an authoritarian type leadership in this village, as far as I know. And I think that we should continue and allow that to be put on the ballot. Let the people of Rantoul decide. If they decide, yes, we'll keep the district, so be it. We'll move on. But let the people decide from that point. Thank you.
Next, we have John Kraft.
I want to speak to the referendum. I'm honestly disappointed that it was even collected signatures and presented. Number one, because the village hasn't been operating for 4 years under the district. And moving away from districts essentially limits or maybe even eliminates any chance of minority representation that the statute provides for a city. You can do that in a city, but it doesn't essentially provide that for a village other than through a districting process. And to get rid of the districting, especially prior to operating under the district system for 4 years, does a disservice to the residents. Thank you.
Next, we have Kirk Allen.
Thank you. My name is Kirk Allen, co-founder of Edgar County Watchdogs. We're a local government accountability organization. And I'm just going to speak to a couple things that have nothing to do with your referendum. They have to do with your public comment. On your policy, or well, actually on your agenda, it outlines comments will be limited to 3 minutes for each speaker. And this is a Village of Rantoul letterhead. That may be an adopted policy you have for the village, but this is a public body separate and distinct. Has this public body ever adopted a public comment policy? And I'm not expecting to answer a question. I'm just throwing that out there to think about in the future. And I don't think anybody here is going to speak more than 3 minutes. It's not like it's an issue. But this is an electoral board, not the village. This body would need to adopt a policy that would restrict people's time frame. And I don't think that's happened. The other thing on the sign-up sheet, it referenced that the speaker has to reference or has to address the board, not individual trustees. Well, you folks aren't trustees, you're electoral board members in this capacity. But even if you were trustees, the public has the right to address each and every board member individually. And that's clearly spelled out in OMA with the person's right to address their elected officials, not as one whole body. So I'd ask that you take a look at that in the future and try to clean that up. That's probably not been an issue, but these are things that we look at as an organization to try to focus on more transparency, because when an issue of concern to the public does come up, it becomes an issue if somebody wants to talk for more than 3 minutes and you don't have a policy. Thank you. Appreciate it.
There are no other speakers.
All right, then that ends the public comment section. Thank you. Item 4 is the presentation of the local election authority, Village Clerk Janet Gray. Janet, microphone's yours.
Thank you, Mayor. Speaking to the filing of the referendum that came into my office on December 1st, 2022, Mr. Terry Workman brought in the referendum. I certified it, and I took it down to the Champaign County Clerk's office, and they filed it on that same date, December 1st, 2022. On Wednesday, January 4th, Mr. Jack Anderson, and I don't know if Mr. Goldston was with him or not, came in and filed 3 copies of the objection that we are hearing today. I was not in the office. My deputy clerk took the objection. On the next day, January 5th, I was informed that the objection should be heard at the county level. And I contacted Mr. Anderson and advised him about that. He came in and picked up the copies of the objections and took it down to Mr. Ammon's office down at the Champaign County Clerk office. Because I was named in that, I called the County Clerk's office on Friday, January 6th to see what the status of it was and when or whether they were going to hold a hearing on it. I called again on Monday, January 9th, and they returned that call saying that the county clerk and the state's attorney had determined that this electoral body was the proper body to hear this objection. I then emailed, I believe I emailed rather than called Mr. Anderson and let him know that they would have to pick up the objection packets and bring them back to us. On Tuesday, January 10th, I sent out certified letters to all of the parties, notifying them of this hearing today. I also then, on January 13th, mailed all the parties an updated agenda, the agenda before you now, and the rules and procedures that the Electoral Board was going to approve. Thank you, Mayor.
Okay, very good. Thank you. Now, ladies and gentlemen, we'll have the presentation of the objection from Mr. Jack Anderson. Jack?
Mr. Mayor, before I begin, may I ask a question of procedure with regard to the presentations? On the agenda, there is time for Mr. Goldston and I to make presentations separately. I believe I'll be making the largest presentation. I've worked my time as close as I can, and I am under 15 minutes. But if it were to take a little longer, could I be allowed to continue and Mr. Goldston would forfeit his time that I might use?
Would do that.
Very good. I didn't want the clock to go off and then there'd be a question. Excuse me if my voice is rough. I'm suffering from just a dry voice, if you will. And as such, I may pause and cough or take water at different times. But other than that, I am prepared to begin my statement. Okay. Good afternoon, honorable electoral board members. My name is Jack Anderson. I will be speaking in objection to the proposed petition to place on the April 4th, 2013 ballot the public question, shall the village of Rantoul abandon the method of electing trustees from districts so that districts shall be hereafter elected on the village-wide basis? As named objectors, Mr. Wendell Goldston and I, both residing within the jurisdictional boundaries of the political subdivision of the village, and we are both registered voters herein. We believe the respondent's petition is insufficient, and as such, the public question should not appear on the ballot. For a little background, at the November 6, 2018 general election, 1,725 of Rantoul's voters cast a majority in favor of abandoning the village trustee at-large form of representation to adopting district trustee representation without change to the existing trustee village form of government as provided for under Illinois Municipal Code 3.1-25-80. After the voters adopted the districting referendum, Illinois Municipal Code 3.1-25-75 requires the Board of Trustees by ordinance shall divide the village into 6 compact and contiguous districts equal in population. After 19 months of process and diligent preparation, on June 9, 2020, the trustees approved Ordinance 2649 titled Dividing the Village into 6 Districts for the purpose of electing 1 trustee for each district. After all the districts were established by ordinance, were prospective candidates able to pull their nominating papers, collect petition signatures, file nominating papers with the appropriate election authority, and have their names placed on the electoral ballot. In the April 6, 2021 consolidated elections, the first candidates running for the new 6 districts were elected as district trustees. Those district trustees were subsequently sworn into office and seated on May 4, 2021. These facts are not disputed. The objectors believe the respondents incorrectly interpreted, then applied Section 3.1-25-85 prematurely. And finally, to place the public question to abandon the method of electing trustees by district on the ballot. The statute used by the respondents plainly states, quote, any municipality that has operated for more than 4 years under the provisions of 3.1-25-75 may abandon its method of electing trustees under this or that section. It is the objector's position that the village began to operate under the provisions of 3.1-25-75 when the first district trustees were elected and subsequently sworn into office on May 4, 2021. Accordingly, any petition and election to abandon the district trustee form of representation cannot begin until such time as the village has operated for more than 4 years under such representation. Representation by trustee districts was approved by the voters in the November 6, 2018 referenda under Section 3.1-25-80, which in its closing statement states, quote, "If the question receives a favorable vote of a majority of all votes cast on the proposition, the Board of Trustees shall proceed to district the village, and the election of trustees for the village thereafter shall be in accordance with 3.1-25-75. That section makes the division into districts and temporal requirements for its completion a series of steps upon which the residency requirement or qualification for office and the election of officers by qualified electors are dependent for the election of the district trustees to occur. It is only after the conclusion of these acts that the village can begin to operate with district representation. As such, the village could not begin to operate under district representation until after the April 6, 21 election, and subsequently upon the official swearing in of the first district trustees on May 4th, 2021. The objectors contend Section 3.1-2585 clearly prohibits the filing of the necessary petition for abandonment prior to the time district trustee representation has been in operation for more than 4 full years. In support of the objector's position, we draw upon the 1957 Illinois appellate court case of Mason versus Cutcliffe. In this matter, the electors of Rock Island, Illinois, filed a petition for a public question of abandoning their managerial form of government. Notwithstanding any specific statutory provisions that otherwise, or that only applied to the managerial form of municipal government in effect at the time, the appellate court found the case at hand hinged on the first sentence of the statute under their review, which reads, quote, "Any city or village which has operated for 4 years or more under the managerial form of a municipal government may abandon such in the manner provided." Excuse me. The language in the statute does not say any village which will have operated for 4 years or more. Rather, the language used by the General Assembly is has operated, using the verb third person singular has in the past participle verb operated. The simple past tense of operate indicating a completed action or time. The language in the statute is clear. 4 years or more must have passed before the abandonment process may begin. The appellees in the Rock Island case, as is the same with the objectors before this electoral board, urged the intent of the language, quote, "is clearly to provide a full 4-year trial period which the citizenry have an opportunity to observe the managerial form of municipal government in operation without unrest, expense, or excitement that would necessarily accompany a petition or election." In its essence, the appellate court in Mason versus Cutcliffe instructively provides an overview of the statutory construction and ascertaining the intent of the legislature by consideration of the language employed. The appellate court found, quote, "It seems apparent the General Assembly, by the language it employed, intended the abandonment of the city manager government, including the filing of the petition and holding of an election on the question, not be permitted until the municipality has operated for 4 full years or more under the managerial form of government." The matter before this electoral board today is the legislative intent of the language of 3.1-25-85, where any municipality that has operated for more than 4 years under the provisions of Section 21, 3.1-25-75 may abandon its method of electing trustees. When questioning whether the words of a statute or ordinance are of necessary clarity, a court looks to the language of the law itself for interpretation of the legislative intent in support of case law precedents. 2 years after the appellate court decision in Mason versus Cutlop, the same court heard the case of DeDonker versus City of East Moline. In the DeDonker case, the appellate court recounted its findings in Mason versus Cutlop, and that the court had narrowly addressed the question of whether the filing of a petition to abandon could occur before the 4 full years had passed. The court restated the acts of the petition, election and abandonment or retention, were all part of a series of acts which cannot begin or be considered separate, where the petition is not a preliminary step, but is part of and inclusive of a series of acts towards abandonment. The court additionally found, quote, that none of the various steps in that series of acts, including the petition to abandonment, may precede the expiration of the 4 years, period of time set out in statute. This electoral board, in its consideration of the objection before it today, will find the clarity of the statutory language and the weight of the appellate court's decision in Mason versus Cutlop precedential and the merits germane in regard to the meaning of the language. Has operated for 4 years or more, and thus, after such time has passed, can the petition be filed for abandonment. The objectors so far have addressed so far the intent of the statute from its unambiguous language and the presidential judicial statutory construction of the appellate court. Lastly, with regard to the legislative intent of the General Assembly, with regard to the intent, the General Assembly has not changed the language after 65 years since the Mason versus Cutlop decision. Section 3.1-2585 of the Municipal Code was amended by Public Act 87-1119 on September 16, 1992, 34 years after the decision of the Cutlop case in 1957. If the General Assembly here in Illinois had intended to allow the preliminary steps of the petition and election of a referendum to begin before any municipality had operated for more than 4 years, they would have done so when they amended the code. The language that has operated for 4 years or more remained intact after the Mason versus Cutlop Illinois Appellate Court ruling in the meaning and legislative intent of the language, now having served as legal precedents for 65 years. The objectors believe that Section 3.5-2585 was designed to allow the voting public a minimum of 4 years and no less, during which the electorate could experience and evaluate having trustee representation, district trustee. We are here today because only 20 months had passed since the first district trustees were sworn into office. Your objectors state that the petition for abandonment of the election of trustees by district is insufficient for the reasons previously stated. Wherefore, objectors pray that the petition papers of respondents on the public question for abandonment of electing trustees by district be declared by this electoral board to be insufficient and not in compliance with the laws of the state of Illinois, and that the referendum be stricken, and that this electoral board enter its decision declaring that the public question not be printed on the official ballot at the general municipal election to be held on April 4th, 2023. And that concludes my statement. Thank you.
Secretary, please note the time and what would be the remaining balance for Mr. Wendell. Wendell, are you speaking?
Yes, 4:15.
You, okay. The reason I said that is because he relinquished some of Mr. Wendell's time.
Thank you all. I believe if I chose to continue to speak, I would get 15 minutes. I concur with Mr. Anderson and the rest of us who worked on this. I will reserve any further comment until the rebuttal. Thank you.
Now we're moving into the respondent comment from Mr. Terry Workman.
Thank you for everyone that showed up this afternoon for support of this petition. I'd also like to mention that I've been contacted by many other people that couldn't be here to express their support for this petition and to put it on the ballot. I also thank Mr. Paul Wilson for his time and effort in the research and the legal aspects of this petition. The first thing is a proof of service under the response and objection to the Village of Rantoul Board and Jack Anderson, Wendes Goldstein for not providing all the information necessary under the objection against Janet Gray, Aaron Adams, Terry Workman, Sherry Johnson, and then et al. I don't know who et al. Is. That includes others. I don't know who others are, but under the rules that were adopted just right now, all others are to be provided with all the information and all the objections provided. So all these others haven't been provided any of that information. So that's for future reference. All right, response to this petition. There are several things that are obvious in this, and Mr. Anderson has pointed them out. So I'm going to go through them fairly quickly. Redistricting took place. The dates at which he provided are accurate. The referendum was put on the ballot, and it was done so in November 6, 2018. And we divided into districts. That was the starting date of when districts started. And that was all done following the proper procedures. The first trustees were voted on and elected by the public April 6, 2021. That is correct. The statement of abandonment of district trustees which is 65 ILCS 5/3.1-25 states that they have to be operating for 4 more years. Any municipality that has operated for more than 4 years. The key word here is operated. When did the operation start? When we did this petition, we started and we followed these procedures. And I will say more on that later. In the court case Mr. Anderson has brought up, he has brought up 2 court cases, Mason versus Gutkamp, and also the Donker court case. Both of these court cases have to do with managerial form of government in which mayors were going to lose their jobs. They don't have to do with districts. They don't have to do with districts and trustees being reelected. They have to do with mayors losing their jobs. So that doesn't pertain to us as trustees. Stupid watch. I'm not going to reiterate a bunch of the facts that Mr. Anderson has just reiterated, but I do want to point out some specific things. In the Donker case, it is very similar to what we have here. In the Donker case, the managerial form of government commenced on July 1, 1952. The managerial form of government was established by the election of April 21st, 1953. And a petition to abandon was filed December 19, 1956. And the election was held April 16, 1957. And this is what the case is all about. And what Mr. Anderson failed to mention about in the Donker case, the decision, the court noted that the decision, there was no determination as to the point in the Mason case as the beginning of the operation. In the Donker case, the decision having been that the mayor would have been cut off or terminated from his full term from being elected. The proceedings in the Donker case were that the managerial form of government was the salient point, and therefore the city of Moline were appropriate and within the 4-year guideline. In other words, that July 1st commenced when they voted to go to abandon the districts, when they voted in the Donker case. This is what Mr. Anderson failed to clarify. The decision was that the operation of the government was started when they voted to go to districts, not when it was to be the election. So they were within the 4-year guidelines set by the statutes. The Mason case, there was no determination. Both of these cases and decisions are really not applicable to the village of Rantoul, traditionally. We have been in the 4th District Appellate Court, and approximately a year ago we moved to the 5th District Appellate Court. Both of these decisions emanated from the 2nd District in Northern Illinois. The Donker decision emanated from the 2nd District. To that extent, Donker is disparate from Mason, and Mason is overruled. And the guidance we received from Donker is that, at least in the district, we established a starting point or a calculation. Only cases coming out of the 5th District Appellate Court or the Illinois Supreme Court are binding on the 5th District. Mason and Donker are somewhat limited guidance, but Mason would happen to be a mayor's election. Donker is dispositive of an issue as to when the 4-year period commences. The fact that was completely ignored in the Mason decision. Statute herein is fully different from dealt with in the Mason and Donker cases, in that the provisions and continuation of trustees' participation in government as opposed to removal of mayors in the 2nd District. Unfortunately, in the Mason Court, improperly decided to rewrite the statute by making the filing of a petition to abandon validity of a 4-year prescription of the statute. The objectors seek to have this board rewrite the statute as set forth in 80 to include the filing of a motion to include a petition to abandon ballots violates a 4-year limit. If the legislature had intended to do so, it would enact into statute regarding petition for abandonment of districts. We assume the legislature did not intend absurdly inconvenience or injustice by implanting additional requirements. There are several court cases which also imply that. If the legislature had wanted to put those things in place, limiting those things, they would have done so, and they have not. Pursuant to only statutory provisions which should be made applicable by this board is found in 85, which sets forth that there may be an amendment of the district approach to trustees after it is operated for 4 years. The legislature is not clear as to how 4 years is to be determined. The only case which talked about the date is Donker decision, which makes appropriate dates the date of election. The election will not occur until April 23. Of the utmost importance is the actual amendment will not occur until terms of the duly elected trustees, which will occur in April of 2023. Consequently, it is arguable that the abandonment will not take effect for at a minimum of 2 years after the election. Certainly, the abandonment will not occur within the 4 years since the election creating the districts. April the 6th, 2021 is long past. Consequently, an election may have occurred in April of 2020, authorizing the abandonment of the village will not abandon the method of electing trustees until years after. This sets the current situation which this board is considering wholly independent of the roadblocks of the objections intended to place upon the village. Reading the statute as a whole, that legislation has addressed the continuation in terms of trustees. Again, we should let the voters decide. For reason is respectfully submitted that the board overrule the protests and objectives and require the placement in the ballot of the petition to submit the issue and let the voters decide. Thank you.
So now, Mr. Anderson and Mr. Golson, everybody any rebuttal?
How much time do we have for rebuttal, sir?
Still have your 15 minutes.
Pardon?
You still have your 15 minutes.
Oh, I shouldn't need that. Okay. Thank you. Okay, I'm ready to begin, thank you. Although I'm not sure how I want to start, so bear with me if I'm a little clumsy. I hadn't anticipated that rebuttal. Because it's not compliant with the law, that's why. It was said that the doctor case, it was said that the doctor case has nothing to do with.
Just twist on it. At the very bottom there. Very good.
Oh, here and left it. How do you get that?
I'll be able to hear you.
Yeah, that is important. Thank you. With regard to the doctor case having nothing to do with this matter, that's basically true. With the exception of when the appellate court speaks back to Mason versus Cutler.
Speak up. Get it closer to you.
Talk into the microphone,
When the court in the Doctor case goes back and addresses cut clock, that's when it becomes relevant, though, because I'm really basing our whole affirmative on the cut clock case, the Mason versus cut clock. So allow me to try to address some of the things that were said here. All right. Let me go over this with the cut clock, or the Doctor case. The matter involved the city of East Moline. This is the case that came after Mason. City of East Moline, which had an aldermanic form of government. In July of '52, by favorable referendum, the city would be changed to a managerial form of municipal government. In April and May of '53, the mayor and 4 councilmen were elected and took office under the managerial form of government. In December 1956, citizens of the city of West Moline filed a petition to abandon the managerial form of government. This was 4 years and 5 months after the passage of the July '52 referendum, and 3 years and 7 months after the election of the mayor and 4 trustees. With no objections, the petition was placed on the April '57 ballot and passed, receiving the majority of the vote, 52%. At that time, the state of Illinois' Revised Cities and Villages Act, the predecessor to today's Illinois Municipal Code, under Article 20-13, allowed the abandonment of a managerial form of government only after it had operated for 4 years or more. And we're used to that language because that's what we've been talking about today. The city took the position that even though there was a vote in favor of a referendum, the city took the position that the abandonment petition was premature. Having taken place before the passing of 4 years, contending the city began operating as a managerial form of government only after the election of the municipal officers and their taking office. The city then adopted a resolution not to abide by the result of the election, imagine that, and to abandon and declare the results void and of no effect. So, off to court we go, right? Because that is the step. There is no electoral board when you're dealing with managerial forms of government. It goes straight to the circuit court. And in this case, it did go to the circuit court, and the next step was, of course, the appellate court. The matter before the appellate court, which found that under existing specific revised city and village act statutes at the time, applicable only to the managerial form of government, the city had rights, powers, and authority by statute to vest itself through adoption and be enforced. Thus, the clock for when the city begins operating as a managerial form of government was upon the favorable election of the referendum. So that was absolutely right. When they voted in 52, and there was an approval, well, was it 52 or 50? Yeah, 52. That's when that clock began. And then when they came up with their referendum, it was actually 4 years after that. It was not 3 months, 3 years and some months. That's because we're talking about the city of East Moline. And the city of East Moline was under the managerial form of government. It has an entire different section within the statutes that says it becomes a city. Or, I'm sorry, the effects of the election are effective then. And that's what the appellate court pointed out. But while the appellate court was looking at that and made that decision, rightfully, in accordance with the statute, and today that statute still exists. It exists under Section 5 of the Municipal Code. Allow me to read to you what the appellate court said in the Doctor, which had nothing really to do with the Doctor. They went back and started talking about Mason, because they're ruling different now, aren't they? In Mason, they said the clock starts once you have elected those officials and they've been placed into office. They begin functioning. In the doctor, they're saying, well, no, there's existing statute under municipal managerial municipalities that say it becomes effective upon the election or upon the referendum that goes into that. So allow me to read real quick. The court says this in the docket. The sole issue before us was this, and they're talking about Mason. The sole issue before us was the sufficiency of the petition, and the precise question was whether paragraph 20-13 permits the filing of such a petition before the municipality has had a full 4 years of city management government. We held it did not. That the petition, election, abandonment, or retention of the city government are parts of a series of acts. That it was not intended that the petition or election be mere preliminary steps of abandonment. And that none of the various steps in that series of acts, including the petition to abandon, may precede the expiration of the 4 years of time set out in the statute. There is no issue before us here, and we did not determine that or when was the point of the beginning of the operation of the city under the managerial form of government, form which we required for the 4 year period. In essence, the doctor has nothing to do with what we're doing today except when the court reaffirms what it said in Mason. And in Mason they said it does not start, the clock does not start until the officials are elected, not when the referendum was passed, because in this case it was passed back in 2018. It's when the representatives, district representatives are elected and they are sworn into office 20 months ago. And the court specifically says it was the legislature's intent that go unchallenged with a referenda or a petition until that time had expired. And they're very specific about that, and I read through all that. And let me see, I made a few more notes on Mr. Workman's comments. I think I covered most of them. But I did want to say this, I thought it was of interest. Today, well, at the time of the doctor case, or for managerial forms of government, they started the clock when the referenda passed, right? That's what the decision was in the docket. However, if you look at today's statutes under municipal code, under section 5, pertaining only to the managerial form of government, it specifically reads, I could pull it up, but to the effect, it says that the clock, under the managerial form of government, it begins to function as a managerial form of government if that's adopted once they have appointed a manager, not when the referendum was passed. Because obviously you can't start a managerial form of government until you have a manager and you start functioning as a managerial form of government. And that's the argument here by the objectors. You cannot begin to act as a village with district representation until you have gone through the steps, which were done, and then you elect your representatives by district, and then they are sworn into office, and they begin to act in their official capacity. Now you are engaged in district representation. And according to the appellate court, which is not binding, but it's guidelines, and I'm sure any other court would look at that, and I'm sure they have over the years, and said this makes sense. You cannot be something until you have all the components present and you begin to function in that manner. And as far as his closing statement, let the voters decide, it's not the voters' decision on whether or not this gets on the ballot. It's a matter of statute and case law. That opportunity for the voters to decide existed back in November of 2018, and the voters spoke. And the statutes allow it to return, not today, in the future. And that concludes my responses. Thank you.
Mr. Wilson?
I think there's some information that we're overlooking. And we keep talking about letting the voters decide. 1,725 people did decide. However, that was done in November of 2018. This is January 2023. And we are looking forward to an election that's coming up. And right now, the 4 years is not being put in place as it should be. Will have, shall have, different until it has operated for 4 years is what we're looking at. Mr. Workman stated that we think that it's going to automatically drop out and those persons who are in position automatically come out. That's not what's before us. What's before us is the 4 years. This is what we worked on, the 4 years for the people. The decision that they made at that time, they are to be able to see that out. Well, it's not working. It has to be given the opportunity first to work before you say it's not working. It has to be given the opportunity to work before you say it's not working. When you say it's not working right now, you're telling us that you do not want it to work, which I don't think anyone would say that out and out. Great things come with great thought. 4 years, 4 years. We have to look at that. The 4 years. April, May 4. May 4, 2020 was it. So we're looking at the 4 year, not the 2 year, the 4. As far as operation and operate, we're talking about people that were voted for, who are in position, who are doing the work for the constituency, and this is being upended because we don't see it working. And it is working, but there are steps that's involved in this for it to work for the 4 years. Not stopping it in midstream and say the current is going 5 miles an hour and we want it to go 4, 3, 2, 1, or even more so, standing still. We are looking at what is happening. No, we are not putting up roadblocks for the village. That was stated. There are no roadblocks for the village. We, as the constituency, as the citizenry of this community don't want roadblocks. 46 years, I've looked at Rantoul as a kaleidoscope. We want it to be a kaleidoscope. There are no coin tosses on who gets to decide. The people decide. But today, on this date, 17 January, it's this decision of the board, this electoral board, to decide whether it's been 20 months or 48 months. Further down in here, it says 46 months. Whether it's been 20 months or 46 months. Many educators are in here. That's not arithmetic. That's common sense. 46 months, if you don't want the 48. That's not mathematics. That's arithmetic. That's common sense. We're talking about the operation of it. They could not have been seated. We had to do the districting for the maps. All of that had to be drawn up. That took time. The election had taken place. They got their petitions. They got their signatures. They turned it in to the clerk. That took time. But in April, the election, and May 4th, that's when the clock started, not November of 2018. You may want it to have started there, but the statute does not say that. It says, given the opportunity for 4 years without interruption. This is interruption. This is interruption. I'm asking that the board, as you are seated, would vote to not place this on the ballot in April. And I pray God's will on each of you.
That is the rebuttal part. Now we have the third rebuttal. Ms. Corcoran.
The process for producing this petition has been carefully followed. The first step was to produce documents following the Illinois Municipal Code 65 ILCS Section 5/3.1-25-85 with the proper wording, which we did. The second step was to circulate petitions and get signatures of not less than 5% of the electors of the village. 5%. The only number we have to go by right now is the election of 2021, which was 7,097 registered voters. That's the only number we have right now because county clerk has not released or publicized the November election results by districts, which we've tried to get several different times and have not received yet. The 5% equals 355 signatures. We attained 550 plus signatures in a short period of time that I gave people to get signatures. we could have attained a lot more signatures had I given people more time to do that. But we have more than enough signatures. We then filed the petition on December 3rd, 2022, as Ms. Gray has pointed out the procedure that we followed. The petition will go on the ballot for the election of April the 4th, 2023. If voted in by the people, some things will happen. First of all, when Dells is worried about trustees not being able to fulfill their obligation, trustees will not be removed from the board because of this petition that have been elected at districts. They will be allowed to fulfill their term. The first election that this petition would go into effect would be 2025, at which time it would go into effect. And then the electorate would elect trustees at large. The trustees elected in the spring will be district trustees. So for the next 2 years, all the trustees on the board will be district trustees still for 2 more years. So we're not getting rid of the people off of the board that have been elected as district trustees for 4 more years, for 2 more years. As is the case in these 2 cases that have been brought up, which are talking totally about getting rid of mayor positions and not trustee positions, which is why they really do not apply to the situation that we're in. The last ordinance to form districts for the village of Rantoul was voted on and passed on November the 6th, 2019. The statement that the managerial form of government must have operated for 4 years before a petition can be filed to abandon is true. The key word that has been bandied around is operated. The only court case that has dealt with that term operation has been Donker. The Mason case didn't address that at all. And the last case, the Mason case, was filed and entered and done on October the 9th, 1957. The Donker case, the decision was made on December the 16th, 1959, 2 years later. Their decision stated that the operation started when the ordinance to form district was voted on. Period. Plain and simple. That's what the law is. That's what the decision was and is. Period. Donker versus East Moline has stated that the operation started when the ordinance to form districts for the village was voted on. The last ordinance to form districts for the village of Rantoul was voted on and passed on November the 6th, 2018. The operation started when the ordinance was voted on and passed on November the 6th, 2018. The filing date of our petition was December 3rd, 2022. That's obviously more than 4 years. The election will be April the 4th, 2023. The petition says, trustees shall be hereafter elected. That means in 2025. The petition should go on the ballot. We should let the people decide whether we should have districts or not. Time has passed. All the trustees will serve their time. End of discussion.
All right, thank you everyone for your participation. All right, board, is there any items you'd like to talk about in consideration of this case? It's now open for your comments.
Mr. Mayor, I have a question or comment, or I guess both.
Maybe put your mic
Is the
closer.
mic on?
Yeah.
Yeah, and I'm kind of hoarse too, so excuse my voice. I guess, and this is probably directed toward our legal counsel, can you explain a bit of the proof of service in regards to what we're dealing with here today?
I think I can, excuse me, and I think just to see some, I think it's relative to the idea of the board rules that were adopted. And just as a quick background, if you recall, a few years ago, there was another electoral board hearing that was relative to nominating papers for a candidate. And some rules were adopted at that time, but those rules were really categorized as specific to that particular issue, which was a candidate's nominating papers. And in my review of that, I felt the rules should account for both possibilities, which is either candidates nominating papers or exactly why we're here today, which is a petition for a public question. The certificate of service, I think, is driven to what may be described in there in terms of like preliminary motions, right? So we know this is going to get scheduled. Maybe one side or the other wants to file a preemptive or preliminary motion on the idea of what they're going to argue about, or maybe what the board should address right up front before anything else happens. And so realistically, that would be driven to the idea of, I need to make sure I serve the other side with it, because this is what I want to argue about first, right? And so appreciate Mr. Workman, I think, providing a certificate of service, indicating service today, I think, really within the hearing of his written response to objections. But I think that's, I don't know that I would say that was an absolute necessity here, because here the hearing is both sides get to say their piece, they get to submit whatever they like to submit during the hearing, and that's why you have rebuttal. And so rebuttal is to address maybe things or points that are brought up within the hearing itself. And so again, hopefully that kind of answers the question.
That's helpful. Thank you.
Great.
I do not have anything now.
In consideration of this case, I'm hearing that at the, get this thing up close. In the consideration of this case, I'm hearing that it's the servitude of the 4 years that all the trustees were originally elected to is what's in question. So I don't see where there would be an objection to that. I'm not having trouble with that, because everybody's going to get a chance to see their 4 years out before this comes into play. Is that, from Mr. Westner, is that how your interpretation is of that also?
I guess, Mayor, what I'll say is this again, not as an advocate for either side of this question.
I understand that.
That ultimately kind of is the issue. both sides have commented about a couple of cases that come from a different appellate court district. What I would suggest is, Mr. Workman suggested that they don't apply, period, because they're not within this district. That's not exactly accurate. And both of those cases really are more driven to the idea of statutory interpretation rather than the nature of the position that's involved in that particular case. So Mr. Workman was pointing out, well, that's the mayor, so it doesn't apply because we're talking about trustees. I would suggest I'm not sure that really is an argument to be made about this because it's driven to interpretation of statute. And I think you hit on ultimately the issue, and it's not really driven by whether the currently elected trustees or those who will be elected at the April election will serve out a particular amount of term. It really boils down to what starts the clock for the statutory reference to a 4-year period of operation.
Okay.
And so that's kind of the issue.
Okay, all right.
And Mr. Mayor, that would be my only comment. And here, state statute has some cases that have been reviewed, but none of them definitely have stated when the districting begins. What is the mechanism that creates it? Is the referendum that says it's going to happen that way occur? Is it an ordinance adopted by the municipality stating here are our districts? Or is it the first election where district trustees are elected?
Yeah, I'm picking up on that as well. Okay, all right.
If I may add,
Yes.
I'm gonna take my mask
Go ahead,
off.
Sam.
So, yeah, if I may add, the question of, like you say, when the clock starts, and both sides made some compelling arguments toward that, to for and against and so forth. So an action in this case, the action of the ordinance taking effect, it doesn't seem that it can take effect without people. Right? We're talking about government, which is people. So if the action started, let's say, and it took 3 years to elect people, then from how I see it, that's when the action starts, that 3 year later. Yeah, that's just, I'm thinking, I'm just talking out loud, thinking out loud, whatever it's saying is. So,
Yeah, you're just hearing it now.
Yeah.
So, yeah.
So, yeah, I just felt the need to say that.
Okay, that's fine, that's fine. Any other comments from the electoral board?
No, sir.
All right. The board, I'm going to ask you to make a decision. So I need a motion to entertain, or I need to entertain a motion to hold the objection before you.
Well, Mr. Mayor, I'll make that motion to entertain the motion to uphold the objection before.
All right.
I will second it.
Madam Clerk, we have a motion on the floor with a second. Would you do a roll call, please?
Mayor Smith,
I vote not to go forward with the objection. I don't know.
Madam Clerk Wright,
No.
Trustee Hall,
I vote to go with the objection.
It does not take unanimous, clerk. If you would please read what the vote was then.
Yes.
the vote is 2 to 1.
Thank you. All right, in which way? Okay.
Which way did it go?
The vote, the motion was to uphold the objection before you. Upholding the objection before you would mean that it would not go on the ballot. The vote was 2 to 1, so the motion did not pass. It was not approved. So therefore, the petition goes on the ballot. Am I correct, Mr. Attorney? Did I explain that correctly?
So it goes
Goes on the ballot. Yes.
just.
All right. Board, I need a motion to adjourn.
Mr. Mayor, I'll make that motion.
I second.
Second. If you would, please, we're not done yet.
There will be a record of decision signed by the electoral board. It will not be immediate because we did not know what the outcome of this meeting would be. But when it is available, it will be sent to all parties that were involved with the objection.
I have a motion on the floor to adjourn, and I'll start with Mr. Hall.
Trustee Hall,
Yes.
Mayor Smith,
Yes.
and Madam Clerk Wright.
Yes.
Ladies and gentlemen, thank you for coming. We are now adjourned.
So I am going to, I don't know if my brain can type it up now or not. What is your availability? Is late tomorrow or Thursday? Take care of him. Okay, but if I,